All right, I will call this meeting to order. The Senate Judiciary Committee has 3 bills in front of us today, waiting on a couple of members to trickle in. I said 12:15, but I'm learning, says to serve in the House, where 12:15 meant 12:15. But in the Senate, it means 12:15 means 12:30, apparently. Just a slower moving body. I'm not really sure if that's a Senate thing or what. Senator Hicks?
Chairman,
I'm a little shocked that it took you 2 weeks to learn that lesson, but just so that you're a little slow on the uptake, but welcome to the Senate, Mr. Chairman.
I will note that and adjust accordingly. All right, go ahead and call roll.
Senator Crago,
Excused.
Senator Crum,
Excused.
Senator Hicks,
Here.
Senator Cole,
Present.
Chairman Olson.
Here.
You have a quorum.
All right, welcome Senator Landon. We have Senate File 101 in front of us. Go ahead and introduce it to us.
Well, Mr. Chairman, thank you very much. And I took the liberty of bringing a couple of friends up here with me just to expedite the process a little bit. Really appreciate the chance to bring you Senate File 101, Mr. Chairman. I'll just jump right in if that meets with your approval.
Please.
So this bill, I hope that after hearing my comments and those of my constituent who happens to be in your august world of professionalism in the active law and knowing a little bit more about this, I'll try to give a little bit of background to the committee and then turn it over to my constituent. This is really a bill, the way I read it, it's an access to justice bill. Under statute 712-303C, convicted individuals must meet a rigorous standard to secure a court-ordered testing of previously untested DNA evidence. The standard, intentionally stringent, is consistent with similar statutes in other states and reflects a careful drafting of the 2008 legislation that Wyoming passed. That's when we passed this law, senators. Some of the momentum from that bill back in the day came from the Rocky Mountain Innocence Foundation. And it's interesting, I actually remember this bill, Mr. Chairman. I believe that Senator Ross was the chairman back then. And I remember taking this bill up. It was quite a national issue. And one that the states followed the federal lead on that. The issue lies in 712-303D, which prohibits courts from ordering DNA testing even when a convicted individual satisfies the high bar in that subsection C, if the conviction occurred after January 1st, 2000. And the individual did not request DNA testing or introduce DNA evidence for strategic or tactical reason. This provision is designed to prevent post-conviction testing from being misused as a second chance for individuals who strategically avoided testing at trial. That rationale is sound. It's a good statute, other than the fact that the chosen cutoff date of 2000 creates the unintended consequence that individuals convicted before 2008, when the act was passed in Wyoming, it would have been impossible to make a strategic or tactical decision based on a statute that didn't exist yet. So we have a hole in the statute from 2000 to 2008. And what this bill does is that it would move that date. Instead of 2000, it would move that date up to 2008 at the time that Wyoming passed this post-conviction DNA law. Now, so that's a quick overview on my part. I've got some experts here with me, Mr. Chairman. I also have the federal law that I'd be happy to bring up to the dais, but I'll take your lead and be glad to answer any questions and move on to those who might be able to shed more light on it.
Okay, let's see if there's any questions for Senator Landon. Otherwise, we'll gladly entertain your experts.
Okay.
All right.
All right.
Senator Kolb does have a question.
Yeah.
Yeah, sorry, Mr. Chairman. Senator Landon, could you delve a little bit into the fiscal note I mean, it would seem like from your testimony that there'd be less of a cost. And I guess I would like to hear your opinion about that on changing this, the date to 2008. Thank you, Mr. Chairman.
Senator Landon?
You know, Mr. Chairman, I greatly appreciate that question, Senator Kolb, and I did not bring it down here with me and did not ponder the fiscal note before coming to committee today, but I can certainly dig a little deeper and find out. You know, it's very possible that Ms. Madden has a thought about what might drive that cost, and I apologize, Mr. Chairman, for that.
All right, let's go to Ms. Madden then.
Thank you, Mr. Chairman and members of the.
Is your mic on?
Let's do it green. Let's get it green.
Green
thank
means
you.
go.
Get real close to the microphone.
Thank you, Mr. Chairman and members of the Senate Judiciary Committee. My name is Emily Madden. I'm born and raised in Torrington, but I currently reside in Casper, where I practice law. I'm a University of Wyoming College of Law grad, and I am also a board member of the Wyoming Trial Lawyers Association. To get right into Senator Kolb's question about the fiscal note, what I can say is that all things considered, the cost of DNA testing is relatively inexpensive, especially when you consider the financial costs that we have when you're talking about imprisoning persons for decades and sometimes life in prison, and also when compared to the moral costs that we have in incarcerating innocent people. And to dive a little bit further into the financial cost, I don't have the numbers in front of me of what it costs per person to be incarcerated, but the people who are trying to seek access to DNA testing under the provisions of Wyoming's Post-Conviction DNA Testing Act are those who are facing considerable sentences. To start with how I got involved in this and the reason that I approached Senator Landon about this bill is because I was appointed by Judge Johnson, one of the federal judges here in Wyoming, to represent Eddie Magallanes in his pursuit of post-conviction DNA testing. Eddie was convicted in 2006 for the murder of Joseph Lopez. Mr. Lopez was tragically killed here in Cheyenne, but Eddie wasn't in Wyoming that night. He was in North Platte, Nebraska, where he resided. There was DNA evidence that was collected from the scene, and it can and it could at the time prove his innocence, but it was and it never has been tested before. What we know is that the first time Eddie ever learned that there was DNA evidence is at the time of his murder trial. And we also know that at the age of 24, Eddie was sentenced to a life in prison without the possibility of parole. And so when you are talking about incarcerating people for decades or for life imprisonment, and they are people who have the hallmarks of wrongful convictions with the need to access this type of DNA evidence for the purpose of presenting claims of factual innocence, it would save the state money if those people who were wrongfully convicted could access that with the relative cost of DNA testing being inexpensive in comparison to the cost of imprisoning him for the rest of his life, which is presumably a couple of more decades, given the fact that he's currently 44. What I will also note is that it's unlikely, if this bill passes, to open the floodgates to other petitions. What we know since the Act's passage is that in the past 16 years, there's only been one exoneration in the state of Wyoming under its provisions, and that was Mr. Andrew Johnson. He was convicted in 1989 and then exonerated in 2013. But notably, subsection D did not apply to Mr. Johnson because he was convicted before 2000, and the state also consented to testing in that case. What I also know is that there are some instances, especially in my client's case, where there are the opportunities for private funding to pay for the DNA testing. And in this instance, there is private funding available for Mr. Magallanes, so there wouldn't be an overburden on public resources, whether that be financial or on the court system itself. And another reason that this wouldn't open the floodgates is because of the opportunity for DNA testing to even begin is that those petitioners must meet that very rigorous standard under subsection C. And I think that's why we don't see more petitions today. And that's for good reason, but I can attest to the fact that Mr. Magallanes does meet that high standard under subsection C, and this amendment does not seek to amend that in any way. If there are any questions, I'd be happy to answer them, but I would also like to thank Senator Landon for his work on this bill, as well as Senator Crum and Senator Crago for co-sponsoring it, and the members of this committee for taking the time to consider this important piece of legislation. Thank you.
Mr. Chairman, you notice that they're not even here.
Noticed that.
They knew this bill was up, and so they took off, but thank you.
We've reached that point in the session where everyone's got bills up in different committees, so they're presenting bills in, I think they're both in the same committee right now, appropriations. Any questions for Ms. Madden? All right, thank you, Ms. Madden. And who is your other witness here?
No problem. Good morning, might be good afternoon, right? Mr. Chairman and Senators Colvin Hicks. My name is Lauren McLean. I live and teach in Laramie for the past 7 years. I'm a professor at law at the College of Law here at the University of Wyoming. Not appearing in that capacity, appearing instead in my own individual capacity as a longtime litigator as well as innocence lawyer as well. And I was a DNA staff attorney for many years, or for a substantial amount of time as well. So just to give you a brief background, because I'm about to start talking about science. So I feel like I need to lay the foundation under Evidence Rule 702 for the lawyers in the room anyway. I have been either public defender, criminal defense attorney, or law professor for the past 16 years. One of my specialties since 2009 has been forensic science. I've tried a numerous amount of DUI cases, DNA cases, ballistic cases, things of that nature. And I'm proud to say that the University of Wyoming is one of 42 law schools. There's almost 250 law schools in our nation that teaches forensic science, which is an incredible skill that our our students learn and can take out into the world with them. So part of my duties is to teach them forensic evidence, including DNA. And as I mentioned, I was a DNA staff attorney at the Washington Innocence Project, formerly the Innocence Project Northwest, where I learned a substantial amount about DNA. And what I would like to speak with you about is how we can make this statute more, I think, intellectually honest and forensically honest. And so I'm going to dive into a little bit of science, and I will certainly take questions. But what you're going to hear really speaks to three concepts related to DNA testing: sample size, degradation, and distinguishing profiles. And all three of those things become important from 1986 or 1984, really, when DNA first comes on board, all the way up until today, as we sit here, 2025. As you may know, over 99% of our DNA sequences as human beings are actually identical, which is pretty funny because we can't seem to agree on much, it seems, these days. But we are 99%, if not more, identical. But we do differ in several what we call loci, locations in our DNA sequencing. And DNA's job is to look at those very particular loci, locations, to determine, to find the differences among human beings, among DNA profiles. And the techniques for looking at what we call alleles, which is part of our DNA, and that's what really separates us from one another, have changed substantially since the 1980s. So in the 1980s, we used something called RLFP, which is called restriction fragment length polymorphism. So RFLP was designed by a gentleman by the name of Alec Jeffreys. And some folks who geek out like I do might remember the first DNA case in England in 1986. Jeffreys was actually involved in solving that case. The funny thing about RFLP is it took months, some weeks, months to actually process DNA. Now today at DCI and the crime lab, it takes a few hours. Essentially what would happen is they would use what's called a restriction enzyme that would work like scissors and cut the DNA into small pieces and then would analyze it from there. And what would be printed out would look like a barcode you might see at the grocery store on one of your products that you buy. And that was called a DNA fingerprint. The problem with RFLP, besides the fact that it took forever to process, was that it needed a huge amount of DNA. And what we find in cases often is that you might have incidental contact. Not all cases have substantial physical contact. And therefore, it may be that not a whole lot of DNA is left behind, but we also know that we leave our DNA everywhere. In fact, Chairman Olson, you might have DNA in a place you've never been, right? That's the way this works. So in addition, RFLP needed a high quality sample. It needed a sample that was not degraded. Degradation can happen based on weather, moisture in the air, dust, those things, mishandling the evidentiary items. And so as a result, RFLP, while it was a breakthrough, of course, DNA in and of itself wasn't incredibly reliable. We then moved into something called PCR testing and short tandem repeat testing. That's what we have today. So PCR came on board and really started to take off in the 90s. And that allows amplification of DNA samples where essentially they like forensically light up, fluorescently, light up, and you can actually see the sequences. And so that comes on board along with short tandem repeat testing in the 1990s. And since about 1998, these STR markers, short tandem repeat markers, have been performed in the criminal justice system. This is also in the 90s where you start to see private laboratories come on board as well. So Bodie Cellmark Forensics is one that's been around since 1995, been involved in a number of criminal cases, not just innocence cases. In fact, many of the crime labs across the nation would contract with Bodie Forensics to help them solve their DNA cases. In preparing for today's testimony, I also talked to Scott McWilliams, who's the assistant director of Wyoming DCI Crime Lab, and he reported to me that Wyoming actually began sending out samples, DNA samples for testing in the mid-1990s, which was interesting to me as I think about the year 2000 and why that cutoff if we were already doing DNA testing in the mid-1990s here. In addition, I think it's important to realize that CODIS, which is the combined DNA index system that the FBI uses to store hundreds of thousands of profiles, did not actually come on board till the 1990s. So we wouldn't even really have a system to compare a profile to until that period of time. I think just some final comments, what I will say is that by the year 2008, we are starting to look at an increased technology that's capable of picking up very small samples, capable of reading degraded samples, and we're more capable of distinguishing between profiles. It gets substantially better, though, far beyond 2008. So I guess as a litigator, I would actually like to see the date even further, but I understand where we're at today and of the hard work that's been put in by Senator Landon, Ms. Madden, and as you consider this, so I appreciate any change that can be made. But just to give you an example, we used to only be able to look in 2008 at 13 of these loci. We can now look at 27 locations in the DNA sequencing. We can really tell people apart. We also now use something called probabilistic genotyping. So the analyst no longer has to assign a percentage of how sure they are that somebody's profile is present in a evidentiary sample. Instead, a machine using technology that's been around for maybe not centuries, but multiple decades. Now the machine does that math for them, and that's been around since 2010. So what I'm saying is the DNA testing got substantially better in 2008. We could look at more locations. We could look at DNA that's degraded and still find the profiles. We didn't need as much sample size, and we could distinguish profiles much better. We're even more capable of doing so today with the technology that we have. So with that, I hit you with some science. I'm happy to answer any questions you have or just walk away, and thank you for your time. Thank you.
Committee? I want to see Senator Landon repeat all of that expert testimony on the floor.
Look like my students sometimes claim where are you going with this. So thank you for your time.
All right, thank you.
Mr. Chairman, I'll do a better job if the bill moves forward to get to the bottom of exactly what we think will happen regarding the fiscal note. It looks like it's going to be pretty negligible for all the reasons that Ms. Madden gave us, but I'll do a little bit better job of being able to answer the senator. So,
Okay, we appreciate that. Thank you both. Anyone in the room wishing to testify on this bill? How about online? No? Okay, I will close public comment. Committee, what is your pleasure?
Move the bill.
Been moved by Senator Kolb. Any amendments to this bill? Any discussion on this bill? Senator Kolb?
Thank you, Mr. Chairman. I think without knowing the cost or what the impacts are, it's really probably difficult to get an amendment right now. I think, there's a lot of things to talk about, but I don't know enough about it to come up with something at this moment in time.
Okay.
Question.
Pierre, will you do a roll call vote on Senate File 101?
Senator Crago,
Excused.
Senator Crum,
Excused.
Senator Hicks,
Here, aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
3 ayes, 2 excused.
And actually, I know they're presenting bills, so let's go ahead and leave the vote open,
Okay.
in case they do come back and they didn't leave you with a sheet, right?
No, they did not.
Okay, yeah, if I'm okay with them, voting if they want to, so we'll leave it open. Let's go to our next Senate file, Senate File 114, Senator Landon. Missing persons reporting requirement.
Mr. Chairman, thank you for the opportunity to bring you Senate File 114 rather hurriedly. I'll try to get my stuff together to present this bill. So, Mr. Chairman, I handed out a proposed amendment. That was something that after we drafted this bill was caught on a couple of fronts. My former co-chairman and your co-chairman on the other side was actually one of the ones who caught the situation where it might be reasonable not to broadcast or highlight a particular person who might be missing, just for safety purposes. And so we can certainly get to that in a little bit, but I want to give you some background real quickly on this bill, Mr. Chairman. I'll just launch right in. So Wyoming, Mr. Chairman, requires DCI to collect missing person data and publish a report, but there's no requirement for law enforcement to accept reports of missing persons. Law enforcement agencies operate under differing policies since no law establishes a consistent model for accepting such reports. In a few instances, law enforcement agencies may believe that another law enforcement entity might be the primary reporting agency and thus decline to accept the report of a missing person. This can lead to an unnecessary delay, misunderstandings with family and friends and the missing person. Law enforcement agencies do not want to duplicate efforts or enter the same person multiple times in various governmental and non-governmental databases. This bill, Mr. Chairman, describes a process that prioritizes which agency is responsible for accepting the report and thus diminishing that duplication. Timely reporting and the use of private sector missing person groups can be crucial in getting the information out to the public, often through social media these days. Those private sector entities often will not publish missing person flyers unless corroborated by law enforcement. So it is imperative that agencies accept reports of missing persons in a consistent and timely manner. So this bill outlines a specific procedure for all Wyoming law enforcement agencies to follow when accepting these reports of missing persons It contemplates a litany of issues surrounding these types of cases so that law enforcement can make the right decision immediately. It also offers exceptions for the cases that do not fit the typical missing person procedure, allowing law enforcement to make decisions based on the best interest of the victim. So that is the genesis. Mr. Chairman, I will tell you that Wyoming's a little bit behind on this front. Several other states have worked to be up to speed on consistent ways of handling missing persons report. Unfortunately, the Western United States is pretty well known for unfortunate numbers on this front. And frankly, part of that is our wide open spaces. And unfortunately, part of that is due to our Wind River Indian Reservation over in the western part of the state. Bottom line is we've had a lot of people working on this issue for a while, Mr. Chairman, and the sheriffs and chiefs of police, particularly one of our sheriffs up in the Bighorn Basin, grabbed a hold of this and really took it. Really proud of their effort, and I was honored to take this bill forward on their behalf and on behalf of many, many people who have been working on this missing person issue in Wyoming. And so, Mr. Chairman, I've got someone here who can walk you through the bill. I think Mr. Thompson, if he's back behind me, he can certainly do that. He's been working this during the interim, but I'd be happy to answer any questions. That's the bill.
Any questions for Senator Landon before we walk through the bill? Senator Hicks?
Mr. Chairman, I'll reserve these because his colleague may be better appropriate to answer the questions, so I'll just
Okay.
hold those.
I think that's fine. Mr. Thompson?
Hey, Mr. Chairman, my name is Alan Thompson, the Executive Director of WASCOP, the Chiefs and Sheriffs Association. And as we look at page one, it kind of just outlines the intent of the bill. Towards the bottom, we get into the meat and potatoes of what creates new law in Wyoming, starting on line 12 on page one. And rather than read each section of it, Mr. Chairman, I think it kind of speaks to itself. It outlines what this is about, and then it goes through the step-by-step process in a couple of sections on page 2, and then even into page 3 with that subsection B coming up. And it looks to contemplate any of the issues that we face in struggles that we get in law enforcement and the private sector, communicating about where the appropriate place is to be the primary jurisdiction, I guess. I mean, oftentimes these missing person cases just need that primary jurisdiction to take a hold of it, gather all the information that they can, and start considering it a case that needs investigation. And then we can fan out from there to ask for support from other agencies in different areas outside of the state and whatever it may be. And we understand that the jurisdiction of Wyoming law enforcement is limited just to Wyoming and to the areas that they serve. And one thing I would like to point out, Mr. Chairman, is that there are times when law enforcement tends to think, and I think that's why we're having this discussion today as one of the last states in the United States to have a protocol written in law. Law enforcement believes they're doing this right all the time, but then we find out sometimes we're not. And I think law enforcement needs to be accountable to those families and missing persons, and being able to have a straightforward playbook to look at and read through. We leaned heavily on existing law in other states surrounding us, like Colorado and Montana. And I think what we have before you is something that helps us, and actually, more importantly, helps those third-party entities that are seeking to help us solve these cases. I'd be happy to answer any questions if you have any, Mr. Chairman.
Mr. Thompson, on page 2, the list of exceptions, does that come out of law from one of those other states that you're referencing, or how did you come up with the list of exceptions?
Yeah, Mr. Chairman, we did some research on that, and the topics themselves come from existing law in other states. I don't remember off the top of my head adding anything that was specific to Wyoming. The wording itself has changed with LSO's, conforming the writing into acceptable Wyoming law. So, but the intent of each of those subsections, we believe, are existing in other states also.
And on Roman numeral 5, this could just be, this is a drafting question, but if you help me understand it, then I'll at least know where it's headed. So on line 22, there's an and between the two statements. And what I'm trying to figure out is if you want both of them to apply to this scenario. So the person reporting the missing person is unable to articulate reasonable knowledge of the missing person. Is that enough by itself to create the exception? And then the other exception is a legitimate reason for the concern of the missing person's health, safety, or welfare can't be articulated? Or is it your intent that both of those situations be met in order for the exception to exist?
Yeah, Mr. Chairman, I do remember that specifically coming from language I'd seen elsewhere, and it listed and. But as I look at it now,
be
it
an
would
or.
make more sense to be an or.
That's
in
what I
that
was
case.
thinking. Okay. Senator Hicks?
Yeah, Mr. Chairman, Alan, page 2, and it gets to Romanet 3. This is another one of the exceptions. And it says a person reported missing is not a resident of Wyoming. And the question I have, seeing as how we literally have millions of people come into the state of Wyoming every year, particularly with our national parks and national monuments. So let's assume that my spouse or my daughter or somebody disappeared someplace. We would literally not accept a missing report because they're from out of state. That's the way I read this. Why is that in there? So do they have to go all the way back to Michigan to file a missing report case when somebody became missing in Wyoming? Help me out here, because I don't understand this.
Mr. Thompson?
Mr. Chairman, that is a really good point, and I think it was something in our discussions with jurisdiction that this came up as kind of an after. And I think one consideration would be changing the and on line 13 to unless. Because I think the intent of that is not to, if the most recent verifiable location of the person is in Wyoming, then that likely indicates that most of the viable leads generated from that location, and it would make sense to initiate the investigation at that location. So it is not our intent to do that for out-of-state persons. But I would absolutely leave it to the committee for best language there, with the understanding that we do support anybody that's known to be or verified to be in Wyoming. I think that that's Wyoming's law enforcement problem.
Well, Mr. Chairman, if they broke the law, I'm pretty sure they're in your jurisdiction and you'll take care of this. I had another one, Mr. Chairman, if we turn over to page 3, and we get to the exceptions under Romanet 6, and it gets down to, I understand the law enforcement agency suspects and can articulate that the person reported as missing and intended to be lawfully flee. That's pretty clear. What I don't understand, or is being sought for reasons of harassment, stalking, or retaliation. And how many more do we need to add on to that list for reasons that they may have intended to lawfully flee? My question, why are we taking something if they intend to lawfully flee, and then we say, or if they're being sought for these other, which are criminal acts, right? Why did we just enumerate those 3 out there when it could be theft or fraud or a whole list of things that the reason they're fleeing? I don't understand why we brought that in to this particular section for the exemptions.
Mr. Thompson?
Yeah, Mr. Chairman, this contemplates a bunch of different things that we would see in our experience with missing persons. So the first part of that, lawfully flee, I mean, it is in some cases lawfully, it is lawful to flee from upcoming criminal charges. So we don't want law enforcement to be using this as a mechanism to find someone when we should be using the criminal process of warrants an NCIC. But what the second part of that means is oftentimes we have the reporting person reporting another person missing so that they can find them. We see that a lot of times in separations and divorces, child custody issues, and law enforcement can learn early in that investigation that the person doesn't appear to be in danger or missing. They have simply fled of their own accord. And so I'm not sure what language would better clarify the difference between our intent in this is lawfully fleeing for whatever reason they want to lawfully flee for, or a separate thought process of the reporting person is simply reporting them because they want to find them. And that would constitute some forms of harassment, stalking, or retaliation as a result of that, if that answers the question, Mr.
Yeah,
Chairman.
Mr. Chairman,
Senator
it
Hicks.
does in those cases, but I'm always cognizant of the fact that when we enumerate those three, what the one that you just articulated was, well, what happened in the case of child custody? Do we need to add that to the list? And then what else do we add to the list? So I've always, Mr. Chairman, every time we enumerate a short list, we always miss those exceptions. And my experience down here in another year or two, we'll be back here adding 2 or 3 others to that list. And so I would wondering if we could work on some, even if it's a committee of the whole amendment, some language to not enumerate those 3 specifics, because obviously based on the testimony, I think we would want to include child custody in here because that's probably pretty common.
And I'm curious, Mr. Thompson, how you would know that you get the report from an individual, maybe it is the spouse and there's a separation that's occurred, but you wouldn't necessarily know that. You wouldn't know that they where they were trying to locate, the person reporting was trying to locate them. How would you know? What type of scenario would it be that would give you that information?
Yeah, Mr. Chairman, that happens a lot. And usually the first call is to the family members of the missing person. So when we call mom and mom says, I know exactly where she's at or he's at, and I really don't want to tell you, but they're safe and sound. And law enforcement reasonably believes that a mother or father has the best interest of their child at heart and would probably not want to take the investigation much further. And if I may offer a suggestion to expand that list without expanding the list.
Yes,
If you
please.
look on line 4, towards the end of it, I think you could say, or is being sought for reasons such as harassment, stalking, or retaliation, or including but not limited to harassment, stalking, or retaliation.
Mr. Chairman, I appreciate Mr. Thompson on that front. I think, after drafting this and looking at it, knowing the kind of effort and time we put into our harassment and stalking statutes over the last 5 years or so, it seemed like the kind of list that would probably be fine, but I like what was just suggested by the senator and Mr. Thompson, because then that way it doesn't limit to just those 3.
It's good addition. Other questions for Mr. Thompson? Senator Kolb?
Thank you, Mr. Chairman. Well, could we get an explanation or a scenario that doesn't take a half an hour to explain what is the problem in the state of Wyoming currently and why we need this bill? I mean, I realize it's a long process everyone's gone through, but the rest of the floor of the Senate hasn't. Certainly I haven't. So could you give an example of a glaring problem?
I also think, Senator Kolb, there's a lot of testimony in the room that will.
Well, from a
Bring
law
that to
enforcement
light.
point of view, Mr.
Okay.
Chairman, that's what I'd like to know, because you're the people in between the folks with a problem and trying to figure out what to do with it. So I'd just like to know, as a law enforcement perspective, what do you see as the largest problem we have and why we need this bill? That's the simple question. Thank you, Mr. Chairman.
Okay, Mr. Thompson?
Yeah, Mr. Chairman, quickly an example I can give you from Montana that would probably predate this. a person works in one county, lives in another county, and routinely drives across a treacherous mountain road in the wintertime. And the subject leaves work at 5 o'clock and was expected home at 7 p.m. Midnight rolls around, law enforcement is called, and typically law enforcement, a resident will call law enforcement of the jurisdiction that they live in first. And can be, and in this case, we're told that's a problem for the next county, you need to call them. Call the next county and they say that's a problem for your county, you need to report it to your local law enforcement. And I think this outlines ways that we could avoid those pointing of fingers. And also, I would like to say that law enforcement in Wyoming has believed that this is not an issue. And I think that you might hear testimony today that it can be an issue in Wyoming.
So, Mr. Chairman,
Senator, yes.
I had a good piece of help on this bill from one of my students over at the University of Wyoming, who is serving here in the Senate, is kind of helping out. And I want to read what he said after all the homework that he did out across the country looking at some things. He said, speaking from personal experience in regard to a missing persons case in Albany County last year, a lot of people here felt that there was poor communication from law enforcement in regard to how the case was communicated to the public. UW had a student go missing and there was no communication to the campus community except Facebook and posts on social media. So that's a very good description from a student who is over there right now as to why I think we need protocols in place so that everybody's on the same page. Wyoming is in a position, Mr. Chairman, where we travel a lot. There's a lot of distance between places. We've got jurisdictional issues that we're all aware of on the Judiciary Committee. You take the reservation, for example. We already know that we've got challenges sometimes there. But you go on a trip up to the Wind River Mountains and you get back home to Washakie County and somebody said, well, where's Charlie? And you report it to Washakie County and Washakie County said, well, he's probably missing in Fremont County. You really ought to contact Fremont County. So that's really what these protocols, I think, in the homework we did out across other states, it has made a difference. So.
Very good. Let's get some of that public comment. Do we have any agencies wishing to testify? Yes, Ms. Chambers.
Yes, I said, please stay put. Yes, I do. Thank you. Good afternoon, Chairman. My name's Kara Chambers. I'm the Director of the Division of Victim Services with the Attorney General's Office. I just wanted to jump in because of some of the questions that were just asked of the gentleman here. And I want to remind everyone that these lists of enumerated exceptions are why they shouldn't take a report. And so you do want to keep that very narrowly tailored so that we're not giving reasons not to take a report. Because remember, that is what has been of the greater concern. So you will hear testimony in a moment from the lead researcher on the Missing in Wyoming and report, which was commissioned by my office on behalf of the Missing and Murdered Indigenous Persons Task Force. One of the many reports commissioned was looking at state laws and reporting procedure, and that's where we discovered that Wyoming was missing a lot of protocol when it came to that, and I'll leave it be. But just to specifically hone in on the questions on page 2 with Roman numerat 3, which says the person reported missing is not a resident of Wyoming and the most recent verifiable location of the person missing was not in Wyoming. Remember, we're saying that's why you shouldn't, or you can not report it. So we want to keep that broad so that we have as many opportunities to have someone reported. And I felt like the question misunderstood that. And that the same with page 3, beginning on line 2 with Roman numerat 6, we're trying to narrowly tailor a reason a law enforcement can refuse. And so we're saying Specifically, this I think speaks to when you have victims of domestic violence fleeing, or someone, like you said, pursuing with ill intent. That would be the narrow reason why you wouldn't want to report someone missing or try to expose someone's location. So I just felt that some of the testimony got a little bit away. Oh, and yes, and I do see, this is why I wanted you to stay. There is a proposed amendment to maybe address additional language, but I did think we kind of we're forgetting what we're enumerating. Not that's the reason when you can, it's the reason when you could reasonably not take a report, because we want to have as many chances to make a report to find people.
Okay, any questions for Ms. Chambers? All right, thank you.
Thank you.
With that, I will open general public comment. If you're going to testify on this bill, please come forward.
Guys,
You can just fill up the chairs, that way we can move through it relatively quickly.
I got
Welcome.
Hi, thanks for having me here. I have a little statement prepared for you. My name is Desiree Tinoco, Desiree-Tinoco. I'm the director and founder of the nonprofit Missing People of Wyoming, which began as a Facebook group over 6 years ago. After hearing of a missing man in my community in Casper and realizing at the time the state did not provide a public missing persons database, I started the Missing People of Wyoming Facebook group, which now has over 35,000 members. 4 years ago, I worked at DCI to get a public database, which has been a wonderful resource, but there's still more work to do, including making sure all of law enforcement is on the same page when investigating and reporting missing persons. This bill is another step in that direction. During this process, there's been a push, not only from the general public, but also loved ones of those that are missing, for more resources and consistency regarding a missing persons protocol. I've since shared my concerns with DCI, WASCOP, and others. In Wyoming, we have no protocols for reporting missing persons. That leads to many inconsistencies among various departments in how these cases are reported, which I can tell you from personal experience has led to many issues in getting them entered into the NCIC database. For example, I have personally seen several cases denied entry due to the individual's lifestyle, income, criminal history, questionable background, or not having a physical address. And I've personally had to go out of my way to push law enforcement in order to get them reported missing. The last time I checked, Gabby Petito did not have a physical address either, but no one had an issue with reporting her missing. To their credit, despite their own tragedy, the Petito family formed a foundation to try to raise awareness for other less fortunate people who don't get that same attention. And unfortunately, most of the people who go missing are not young, blonde, beautiful women, and are often more likely to be minorities, men, the elderly, people with substance abuse or mental health issues, or the so-called undesirables who need our help the most. Likewise, Wyoming has a problem when it comes to missing people. Our state is ranked 12th in the nation for most missing persons, and I would argue that number is higher given our inaccurate numbers at this time. That's the bad news. The good news is there are fixes that won't cost the state a dime to implement. That's why this bill is so important, because it will incorporate a standard for reporting missing people that most states already have in place. This bill would provide guidance and accountability for agencies throughout the state. It would create consistency regarding how missing persons cases are handled, not only within our own jurisdictions, but in cooperating with surrounding states that have similar laws already. This can be a huge benefit when it comes to cases that cross over state or county lines. Assuring that we have correct numbers reported overall for the state, making it easier to determine which agency should and will report an individual missing, and lastly, taking the burden off of nonprofits such as my own in order to report missing persons. At some point, my nonprofit will cease to exist. I've seen nonprofits fizzle out after years of dedication. You'll typically have just a few running a whole nonprofit, and to have such consistency and reliability coming from a non-government entity is questionable at best. If a loved one of those that are missing is lucky enough to find the resources that our nonprofit provides, we do everything within our power to persuade agencies to report their loved one missing. However, not all cases are that lucky. This is also not the work I set out to do when starting a nonprofit. My fear is over time, these cases will soon fall to the wayside and not be reported or given the assistance they so desperately need. I'll take any questions if you have.
Any questions for Ms. Tinoco? All right, thank you for your testimony.
Thank you so much.
We appreciate it. You're up.
Thank you, Mr. Chairman. Chad Auer, Senior Policy Advisor, Governor Gordon's office. Thank you for this opportunity to briefly express support for this bill and to thank Senator Landon, Ms. Chambers, and a lot of other folks in this room and beyond that have worked hard on this issue. As you know, public safety, particularly when it comes to curbing the epidemic of missing persons cases in Wyoming, is a core priority for the governor, particularly as Missing and Murdered Indigenous Persons Task Force, as well as the legislation and reports that have been produced from that group, have been critical to shedding light on underreported tragedy of missing tribal members in Wyoming. The governor supports bills such as this one that can enhance law enforcement response, as well as ensure more efficient processing of missing persons reports for people who go missing in Wyoming. Again, Mr. Chairman, thank you for the opportunity to briefly express support for this, and that'll conclude my remarks and yield back. I know you have a number of stakeholders that have important stories to tell.
Any questions for Mr. Auer? All right, thank you.
Thank you.
Appreciate your testimony. Additional public testimony. Oh, well, that tells me what's going to happen with the next bill. All right, online testimony. We do have some online testimony. Okay, you're admitting her now? Welcome, Ms. Grant.
Hi, thank you. Make sure everything is working here. And it just disappeared. Okay, sorry about that. Good afternoon, Chairman Olson and members of the committee. My name is Dr. Emily Grant. I am a senior research scientist at the Wyoming Survey and Analysis Center at the University of Wyoming. Thank you for the opportunity to speak with you today and provide some information relevant to your discussions on the issue of adult missing person protocols. I'm going to attempt to share my screen. I'll just try it once. Okay, you should be looking at my map now. So recently, our team compiled some information to examine missing adult protocols across the United States. This research was commissioned by the Wyoming Division of Victim Services to better understand how other states address these cases and to identify any potential gaps in Wyoming's current practices. Our study began with a review of federal, state, and tribal laws, as well as policies and procedures for handling adult cases. So we analyzed how the states manage reporting, database utilization, and public alert systems. This included evaluating which states require law enforcement agencies to enter missing adult cases into federal systems such as the National Crime Information Center, or NCIC. We found that 40 states and the District of Columbia have mandates requiring law enforcement agencies to enter missing adult cases into NCIC, ensuring that critical information is shared across jurisdictions. By contrast, Wyoming has no legislative requirement for law enforcement agencies to report adult missing persons to any state or federal database. In Wyoming, the discretion for managing adult missing person cases rests with individual law enforcement agencies. While Wyoming does operate a missing persons clearinghouse, it relies on voluntary submissions from agencies, which can lead to inconsistencies in reporting. This contrasts with states that have established mandatory protocols for database entry and alert activation, which often improve coordination and outcomes. It is important to note that our report did not make recommendations, but instead aimed to provide a clear understanding of the current landscape, both nationally and within Wyoming. So we hope that this information will serve as a valuable resource to you as you consider this issue and its implications for Wyoming. Thank you for your time and the opportunity to share the findings of our research.
Any questions, Ms. Grant? Thank you for joining us, Ms. Grant. We appreciate the information.
Thank you.
Now we have one more online. You can try that, yeah.
Hello?
Good afternoon.
Is this Ms. Wagon?
Yes, it is.
All right, go ahead and introduce yourself and tell us what you want us to hear.
Good afternoon, Chairman Olson and members of the committee. My name's Nicole Wagon. I'm here today to speak in support of SF0114 as a mother and an MMIP advocate. Speaking from personal experiences. As you guys may all know, I lost my daughter, Jocelyn Watt, 2019, who was murdered in Fremont County. 2020, I filed my other daughter, Jade Wagon, missing and found deceased. So with that being said, this bill is about something really simple, but incredibly important. Making sure there's a clear and consistent response when an adult goes missing in Wyoming. Right now in Wyoming, when a family reports a missing adult, the response they get depends on where they are and who they talk to. Some law enforcement agencies act quickly, while others tell families they have to wait. Imagine how terrifying that is. Your loved one is missing. You don't know where to turn. And instead of immediate action, you're met with delays and uncertainty. That's not how this should work. We know that the first hours and days after someone disappears are the most critical. I repeat that, most critical. The longer it takes to act, the harder it is and becomes to find them. This issue is especially urgent for Indigenous communities where too often missing person cases don't get the attention they deserve. I personally testified at the Non-Invisible Act Commission in 2023 in Billings, Montana. That testimony resulted in having a missing murdered unit on the Wind River Indian Reservation of Wyoming. A missing murdered unit is a specialized law enforcement unit dedicated to investigating and solving cases involving missing and murdered Indigenous people, specifically focusing on American Indians, Alaska Natives, aiming to address the disappropriate rates of violence and missing persons within these communities by coordinating with tribal, state, and federal agencies to pursue justice for victims and their families. But this isn't just an Indigenous issue. It's something that affects families across Wyoming. No one should have to navigate a confusing or inconsistent system when they're trying to bring a loved one home. Passing SF0114 is a step in the right direction. Having a standardized law enforcement protocol for adults missing persons cases is not just about efficiency, it's about saving lives. SF0114 would ensure that every case is handled with urgency, consistency, and care, regardless of where it happens in the state. This bill would provide law enforcement with clear guidelines, helping officers know exactly what steps to take when an adult is reported missing. It would also give families the reassurance that their concerns are being taken seriously and that their loved one's disappearance is not being dismissed. I urge you to support this bill and help create a system that treats missing persons cases with the urgency and care that they deserve. And with that being said, even with the Gabby Petito case, that coincided when my daughter went missing, Jade Wagon, she did not, I repeat, did not receive the media attention as she so deserved as well. And I am a resident and native U.S. citizen of Wyoming and a full-blood Northern Arapaho tribal member of trying to make a difference in my indigenous communities as well. But that being said, thank you for your time.
Thank you, Ms. Wagon. We empathize with you for your situation that you've had to go through. Deeply sorry that you had to go through that, but we do appreciate you sharing all that information with us. That's it?
Thank you, sir.
Not on my list. They just put the wrong number? Okay. Blackburn. Welcome, Mr. Blackburn.
Good afternoon, Mr. Chairman, honorable senators. Thank you for hearing me. I registered last night. Old sheriffs and smart equipment are not usually good combinations, so I apologize for any confusions. I just wanted to, as a working law enforcement officer, as a 5-term sheriff in the state of Wyoming, I have a lot of experience with missing persons. I want to echo the words that have been done or been said so far. I want to thank Senator Landon for carrying this important legislation forward. I appreciate Senator Hicks's concerns. As a working law enforcement officer, this is a problem. I think, as was well stated in the last testimony, the speed with which we can start processing things and get them into the system is critical. A lot of times, these do involve crimes for the missing persons, and evidence is lost quickly, especially in Wyoming where weather is affected and other areas. I think it's important to remember that if we can get these people in the database as the vehicle is found, a particular incident with us was a vehicle was abandoned on a roadway, and it was quite often by the highway patrol or somebody else, it's marked as an abandoned vehicle, and it can go for a couple of days without anybody listed as a missing person until it comes to the forefront, and then the questions start being asked. When that license plate is run, if that's an associated plate with somebody that's missing, if that's entered in a database in a timely fashion, that's an opportunity for us to go ahead and begin collecting evidence and start our evidentiary procedures. There's also one component to this that hasn't been spoken to, and it's the long-term database. Is these sometimes languish for a long period of time, and we can have a laundry list of the types of crimes. We know that Ted Bundy operated in Wyoming years ago, and we know that there's still bodies that are missing in Wyoming. By having a potential DNA, which links back a little bit to the previous testimony that was given, DNA is on file, having a case on file, it makes it easier for us to work cold cases and bring this back and bring resolution to families who are grieving and would just like the knowledge of their loved one and bring them home, even if it's not the way we all hope to and try to. And so I think that's another component of the bill that needs to be considered as an important component. And the opportunity for law enforcement to work together on is not a big lift. And it gives us kind of a deadline and a little bit of standardization of entering these cases in a timely fashion. There is a case currently active in Wyoming, and it's not my jurisdiction's case, but a gentleman went missing. A welfare check was done. There was nothing out of the ordinary. The vehicle was found a short time later in a different state. And as a result of that, it was not listed as anything, and it was just towed to an impound yard, and it languished there for a few weeks until this case came to the forefront. And these are the types of cases that would be beneficial for this. It also has protections built into it, as was said well by Ms. Chambers, to protect the people that we are trying to protect from the bad guys so that law enforcement is not weaponized. And I think it's very articulable that this is a good bill, and Senator Landon and especially Mr. Thompson, our representative with WASCOP and the Wyoming Sheriff's Association, has spoken so well on. Now, I have had some high visibility missing person cases that have had difficulties with them. And that's why I started realizing the value of people working together on this with these Facebook groups and being able to communicate to the families of our missing persons. And hopefully this will help in some small way to facilitate some of those efforts. And that's my involvement in this. And in the interest of time, I will be brief, but I would be willing to entertain any questions.
All right, thank you, Mr. Blackburn. We appreciate your testimony. Committee, any questions? No? All right. I will close public testimony. Committee, what is your pleasure? Been moved by Senator Kolb. Any amendments on page 2? Senator Hicks.
I think when we go to page 2, go down to line 12, after missing, strike is not a, and go down to line 13 and strike resident of Wyoming and the. So, Mr. Chairman, that will now read the person reported missing, most recent verifiable location of that person reported missing was not in Wyoming. It's still needs a little work there. Okay, I think we can do this. Mr. Chairman,
Yes. I'm trying to work through it.
let me see if I can do this. So if we go down to line 14, we also strike, so we don't have repetitive language is what we're dealing with now. Strike of the person reported missing. So it would now read the person reported missing, most recent verifiable location was not in Wyoming. I think that's what we're trying to get to.
Okay. Any discussion on this amendment? No? Yes?
Thank you, Mr. Chairman. I understand where the good senator's trying to go. I still don't know if it reads quite right. Might be one we could bring on the floor. I mean, I'm happy to work on the language, but it doesn't, I still don't
Between
think.
missing and most, there's something missing.
That's right. Thank you. It doesn't, it doesn't flow quite right, I guess.
Yeah, it would be something like the sentence would start with the most recent verifiable location of the person reported missing was not in Wyoming.
Same thing, it just cleans it up and makes it a little clearer.
Did you get that, Pierre?
So,
I can't do that again. The most recent verifiable location of the person reported missing was not in Wyoming. Does that get to what you want, Senator Hicks?
Yep.
Okay. Any other discussion on this amendment? All right, all those in favor signify by saying aye.
Aye.
Any opposed? That amendment does carry. I do think at the bottom of page 2, line 22, and should be stricken with an or inserted in place of that. I think that I don't know if you were in the room, Senator Craigo, but I talked with Mr. Thompson about that, and he felt like that was more in line with the intent of what they were drafting. So I'll move that.
Second.
All right. Moved and seconded. All those in favor signify by saying aye.
Aye.
Any opposed? That motion does carry. Is there any Amendments on page 3.
Mr. Chairman, just a little discussion on this. It looks like to me, so when we get to the exemptions here on Romanet 5, and so the first part, the law enforcement agency suspects and can articulate that the person reported as a missing intended to lawfully flee. That makes perfect sense to me. Maybe we ought to put a period there, insert a new Roman number 6, and bring in the next concept. If this person is being sought for reasons including but not limited to the following. Seems to me that would kind of clear that up versus looks to me like we're interjecting two different concepts. So we're gonna say the same thing. We're just gonna, instead of having the conjunction of or in there, it just says this exemption and this exemption. But I defer to my legal counsel on this.
Okay. So we could just create a new Romanet
Yep,
after flee.
after flee, yep.
The person being reported is being sought for reasons of harassment, stalking, or retaliation.
Yep.
Is that the new Romanet?
And we talked about
Oh, you want the,
including but not limited to.
so the new Romanet would read, the person reported is being sought for reasons of including but not limited to harassment, stalking, or retaliation,
Correct.
and then renumber accordingly.
Yep.
Okay. Any discussion on this amendment? Just to clarify it, that's fine. All those in favor signify by saying aye.
Aye.
Any opposed? That amendment does carry. Then we have Senator Landon's amendment on this page.
I'd move for adoption, Mr. Chairman.
Okay, we'll move to adopt what is labeled as Amendment 1 to Senate File 114. Pierre, you have a copy of that? Okay, any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Any amendments to page 4? Any amendments to page 5? Any general discussion on this bill? All right, Pierre, will you do a roll call vote on Senate File 114?
Senator Crago,
Aye.
Senator Crum,
Excused.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused.
All right, Senator Landon's already gone. He missed that. That's too bad. All right, with that, we will move to our next bill, Senate File 117. Why don't, if you're here to, you can make your way to the front, Senator Pearson, but if you're here and you're going to testify on this bill, can you raise your hand for me? Okay. So what I'm probably going to do is have Senator Pearson introduce the bill. Then I'm going to go to my agencies and we'll see, and entities of state government, we'll see where we get with that, but my guess is that's probably going to eat most of our time. And then if not, we'll move into public comment and get as much of it as we can. And then I doubt we're going to get through everything in 20 minutes. So we'll probably schedule an additional meeting tomorrow at noon to take the rest of the testimony on this bill. So, Senator Pearson, welcome to Judiciary.
Thank you, Chairman Olson and members of the committee. Where'd they all go? They're all gone.
We have a quorum.
I'm very nervous, as you can see. So what I'm wondering is, I know that I gave you a couple of friendly amendments. Do you want me to read those first, or do you want me to read the bill as is?
No, what I want you to do is give us kind of a general explanation of your bill,
Okay.
and then walk us through your bill, and then let's talk about amendments.
Okay,
But give us your name
oh,
for
sorry.
the record. We know who you are, but it's a formality.
Yeah, my name is Laura Pearson. I represent Senate District 14, Southwest Wyoming.
Go ahead.
The purpose behind this bill, I was asked by a few constituents to run a bill like this, and I truly believe that the Lord sent this my way because not only In my parents' divorce, did they do this? But also in my first divorce, we did the same thing for our children. And so I think that it was just a calling somehow. I don't know how, but so the problem is the assumption, and in many cases, the reality, that in a divorce, one side is favored over the other in a custody case. The solution from this bill is that from the beginning, both parents start on an even playing field. So this bill empowers both parties. It forces the judiciary to honor private agreements. At the end of the day, what is the best interest of the children? To have both parents in their lives, both parents making decisions on their behalf. I think you've received the poll from 2022 on this very issue in Wyoming. And in that poll, 98% in this poll agree that it is in the best interest to have as much time as possible with each parent. In this poll, it says that 87% of those in Wyoming indicated they would support a change in Wyoming law that awards children as much time as possible with each parent after a divorce or separation. In this poll, it says 88% believe that when there is a conflict between parents, awarding sole custody to one parent increases conflict. So therefore, saying that parents working together decreases conflict. And that is in the best interest of the children. In this poll, 92% believe that Wyoming should promote shared parenting for all children with separated parents. And in this poll, it says 95% believe that both parents should have equal rights and responsibilities following a divorce or separation. Decisions are made as far as physical assets, home, cars, retirement, credit cards, etc. But the children are our most valuable asset of all. We need to think of their welfare. So, as I've said, when my parents got divorced, I stayed with my dad. I was raised by my dad. My little sister moved away with my mom to Arizona. But in every case, every decision that was made, they were both talking to each other. Birthdays were spent together, celebrations together, to try to make it as normal as possible. I did the same when I was divorced. We did a lot of things together. If I was disciplining I'll say my son for something that he did before he was supposed to go to his dad's for the weekend, his dad a lot of times would side with me and say, we're not gonna, play both sides here. So that's in the best interest of the children, where they're seeing that both sides are working together. And that both parents are kind of on a even playing field as far as decision making. Both parents deserve, except in some of the mentioned instances in the bill, access and decision-making rights. This is in the best interest of the children. So that's kind of my introduction.
Okay.
Now we can go to the bill. So in the bill, this is just promoting shared parenting. Parents starting off on an even kill when there is a separation or a divorce. And the judge is looking at that. An act relating to child custody, providing a presumption for issuance of an order of shared child custody is specified, providing definitions, specifying applicability, and providing for an effective date. So unless otherwise specified by an agreement between the parties, and that's what is so important about this bill, is that it allows for an agreement between the parties without, and that the judges need to kind of honor those things. In granting a divorce or separation, or annulment of a marriage or upon the establishment of paternity pursuant to WS 14.2.401 through 14.2.907, the court shall make a decree in order any disposition of the children that is in the best interest of the children. In determining the best interest of the children, the court shall consider, but is not limited to, the following factors. The court shall order custody in well-defined terms to promote understanding and compliance by the parties. Custody shall be crafted to promote the best interest of the children. The court shall enter an order of shared custody unless, and so these are the stipulations. A different form of custody has been agreed to in writing, signed by both parties. One or both parties has been adjudged by a court to be guilty of a crime involving domestic violence against the other party. One or both parties have been adjudged by a court to be guilty of cruelty, abuse, neglect, or mistreatment of the children. The parties no longer reside, or this says, but we amended this, the parties no longer reside within 300 miles of each other, and a different physical custody arrangement is the only practical arrangement. Or there is clear and convincing evidence that a different physical custody arrangement is in the best interest of the children. For the purposes of this section, joint legal custody means both parties share in decision-making rights, responsibilities, and authority related to the health, education, and welfare of the children. Joint physical custody means the children physically reside with each party for a substantially equal amount of time each calendar year, with a parental plan crafted to promote the best interest of the children. Shared custody means a child custody arrangement that includes both joint legal custody and joint physical custody. And then it says this would go into effect July 1st, 2025. And then did you want me to explain the amendments and why we,
I believe we've seen your amendment.
yeah, but I didn't know whether the public needed to hear kind of what the amendments might be.
Yeah,
or not.
you can walk us through your amendment.
Okay, so the first amendment was to delete page 3. Let's see, let me get here on my page. The first amendment was on page 1, line 8. It's just adding another subsection there.
You don't have to walk
Oh,
us
I don't
through
have to do
got
that?
that,
Okay.
So
Then-
page 3, lines 5 through
Page
7.
3, lines 5 through 7, we deleted that number 4. We took out the 300-mile limit.
Okay,
The reasoning behind that is because there
Or
is
you-
no,
rather you want to do that.
huh?
You want to do that. You haven't taken it out yet.
No.
The bill is
I
ours.
want to do that,
The
sorry.
bill is ours now.
Sorry, I want to do that. Sorry, bear with me, I'm new, okay?
You're fine.
So the reason that I want to do that is because there is no mile limit that should be necessary to allow as much access as possible and equal decision-making for the children. And so I would like to take that one out. Then on page 3, line 9, where it says there is clear and convincing evidence, I would like to change that to a preponderance of the evidence. And I would like to do that because that was requested by attorneys, thinking that it would be more favorable. Rather than saying that you have to have clear and convincing, it's kind of giving them, You know, like if there was a drug issue or things like that, you know, that they have that freedom to make those decisions. And then I added a section that just basically states, and this is more just to protect if there's false reporting. And it says, for the purposes of this section, the court shall, in considering the best interests of the children, consider whether a parent has made a false or fraudulent claim of domestic violence, sexual violence, child abuse, child abandonment, or child neglect. So, I think that's all I have. Is that all I have?
That's all you.
I think that's all I have.
To my recollection.
Okay.
Pierre, do you have a copy of the, do you have a physical copy of the amendment with you that you could give
Yes.
to staff?
Yes, I do. Sorry, I forgot that I needed to do that.
And
or-
then it's just more helpful if, and easier if we move any of those amendments.
Okay. Yes, sir, I do.
Cool. All right. Any questions for Senator Pearson? Senator Craigo.
Thank you, Mr. Chairman. Thank you, Senator, for bringing your bill. So, a couple questions, and I'm gonna bail right into the first one on your amendment on the 300-mile, actually your proposal to take that out. So, as I read it now, your bill requires 50-50 joint physical custody, which means the child would stay with each parent 50% of the time. Is that correct?
Senator Pearson.
Thank you, Chairman Olson and Senator Craigo. So that is the idea of the bill, yes, that a proportional amount of time with both parents. So I'm saying not every other weekend or things like that, but like I said, I live this. The parents can come to an arrangement. The parents can decide, you know, like Christmas break, for instance. You know, if one parent is gonna be going on a large vacation and wants to take them, then, you know, I mean, there's ways to work around that to maybe not make it 50-50 if there's a large distance. But there's a way to make things agreeable between the parents and not create conflict. And so that's kind of the basis behind it. But I also would like to say that even at 1,000 miles away, parents can pretty much be 50-50 on decision-making on major things for the children, even if they are a large distance away.
Well, you've got two components there. You've got 50-50 on decision-making, but your bill also, by definition, requires a 50-50 split of physical custody. So to Senator Craigo's question is that if they do live 1,000 miles apart, how practical is that they could spend 50% of the time with one parent and the other? If the child is 3 or 4 years old, maybe that's 2 weeks with one parent and 2 weeks with the other parent. That's practical. If the child is 10 years old and is enrolled in school, how does the child spend half of the time at one location and half the time at another location, I think is where Senator Craigo is going.
So like I said, that isn't necessarily practical in that decision, but also in this bill, it does say unless otherwise specified by an agreement between the parties.
Yeah, let's just pretend for your list of exceptions, though, there's two worlds. There's one where they agree, and then the exceptions don't matter. It's just whatever, they can agree to anything in the universe. That's fine. But let's pretend we're in the world where they don't agree, because that's what the list of exceptions is designed to do. It's designed to operate us in a world where the parties aren't agreeing. The judge is required to enter an order of shared custody unless one of these things are present. So parties don't agree. They live 1,000 miles apart.
I think that's why we added in.
Why you had that exception.
That's why I wanted to add in that wording. There is a preponderance of the evidence that a different physical custody arrangement is in the
Okay.
best interest of the children, so that the judge could rightfully so help make that decision,
Okay.
rather than saying that there's clear and convincing evidence. This is allowing the judge, in a situation like that, to help make that decision and have the freedom to make that decision.
Senator Craigo,
Follow up, Mr. Chairman.
please.
Thank you, Mr. Chairman. Good Senator. So my next question is you said the lawyers had, some of your lawyers had prepared these, or lawyers in general. Who exactly was requesting the amendments?
Senator Pearson?
There was, well, he was my divorce attorney, but he, he made the, because when I thought of this, I sent my original bill to him because I want to get feedback from other people, and so there was a suggestion there, also, just to make it easier on the judges. And then also the other day, when I was late for my vote, there was an attorney here for the state that also thought that it would be wise to do that, so.
On your list of exceptions, I'm reading through, like, for example, the exceptions on domestic violence and abuse and neglect. And, I mean, I just think of a scenario, what if one of the parents was convicted of a sexual crime against a minor child, not one of their own children, but another child? Is that worthy of an exception?
I would say yes. I mean, I don't know actually on that. That's, okay, say the question again. I'm sorry, and I'm supposed to address you right. Sorry, Chairman Olson. Okay, so
Okay,
say the question again.
so if one of the parents was convicted of a sexual crime against a minor child, would that be worthy of an exception to not grant shared custody?
Possibly. At what age was that? Like, you would have to think about what age that was, if it's like an 19-year-old boy that was dating a 16-year-old girl, and this is a high school, like, what is it called, statutory rape or something like that, you know what I mean? I would say no. But if it was like a dad that assaulted a child, absolutely yes.
What if one of the parents was convicted of possession and use of methamphetamine in front of, or maybe not even in front of the children? Would that be worthy of an exception?
Yes.
So where I'm getting at with this is one of the struggles that you have when you try to create a list of exceptions. You can't possibly list everything, and maybe that's one of the reasons why we give judges discretion, is because we can't possibly list out every scenario.
Right.
Senator Hicks?
Oh, Mr. Chairman, I just remember like 14 years ago spending on this committee, spending hours and hours and hours redoing this stuff. And to your point, the number of exceptions that came up with parents that, I'll just use one of them, was recently released from prison that had a substance abuse problem, that wanted and filed for joint custody of the child, but was using the child then to try to extort money from her ex to support a drug habit later on. And so all of these things that's just going through my mind of how complex, in a real world where the parents can reasonably agree this would absolutely apply, but there's so many exceptions out there that, it's tremendously complicated. The one question I had for you guys is, because I haven't been on judiciary a long time, but when I read the amendment where we changed it, there's a preponderance and evidence, that lowers the standard if it's not versus clear and convincing. I just want to make sure of that. By
Right.
changing that, it lowers the bar substantially.
Yeah, it's as low as it can go. That's your
Yeah.
lowest standard. Basically, it's think of it as 51%.
Yeah.
And then clear and convincing is somewhere higher than that, and beyond a reasonable doubt is your highest standard. So yes, that would be your lowest possible standard. Other questions for Senator Pearson? We have 2 minutes, so if we don't have any other questions, we'll pause there.
Okay,
And we will have to take your bill back up tomorrow, Friday at noon.
okay.
And we'll move into agency testimony and then collect public comment.
Thank you, Chairman Olson and committee members.
All right, thank you.
Thank you.